بسم الله الرحمن الرحيم. طلاب الفرقة الثانية بقسم شعبة اللغة الانجليزية كلية شريعة وقانون. Today's class inshallah will be about the theory of obligations contract. This is Dr. Ahmed Hamza Mansour. I'm a civil law teacher at Al-Azhar University Faculty of Sharia and Law. Today inshallah we will speak about the promise to enter into a contract. The promise to enter into a contract. You will find it exactly in pages 58 and 59. موضوع النهاردة إن شاء الله هيكون عن الوعد بالتعاقد. الوعد بالتعاقد. What does we mean by the promise to enter into a contract? A promise, it's a kind of a discussion or an agreement to create a future contract or an agreement between maybe persons, individuals, or even companies. This future agreement has the focus of its obligations, which offering something to do or doing an action or refraining from doing an action. For example, a company may make an offer or a promise to another company or to a charity organization to provide a donation, money for them, or to buy something or to lease something. Now, from the legal perspective, can we mention or can we say that this promise is it enforceable or not from the legal perspective? From the legal perspective. In the Egyptian Civil Code, particularly in Articles 101 and 102, govern this whole issue. These articles mention that in an agreement by which two parties or more promises to enter into a particular contract in the future is not concluded unless all the essential points of the contract and at the time in which the contract should be concluded were determined. When the law provides that the contract shall not be valid unless certain form is observed, this form must be observed. What does exactly this text mean? It means that a promise is a promise and cannot be final or enforceable unless three conditions that have to be met. هذا النص ينص على أن العقد غير واجب النفاذ ليس نهائيا إلا في حالة وجود ثلاثة شروط. The first condition that have to be found is that the parties of the promise themselves have to make an agreement. There should have been an agreement, not a joke. لا بد من وجود اتفاق ما بين الأفراد. والأفراد في هذا المضمون قد يقصد بهم الأفراد الطبيعيين أو الأشخاص الطبيعيين مثلي ومثل غيري، وقد يقصد بهم الأشخاص ذوي الأهلية الاعتبارية أمثال الشركات. This also means that the agreement must have the person who are making this promise must have the capacity to do so. They are not they don't have any partial disability or any other issues that make this agreement or promise not valid. Now, the second question, this leads us to the second question. The second condition that have to be found is that the promise must include all the essential elements of the contract. لا بد من وجود كافة المسائل الجوهرية في داخل الوعد المتعلقة بذلك العقد. This means that the contract should have an object. لا بد من وجود محل العقد. There should be a price. لا بد من وجود ثمن. There should be a location for the contract. There should be a time where the duration period must be, the promise must be executed within this period. Now this leads us to the third question, to the third condition. The third condition mentioned that in order to have this promise enforceable, it must include a duration period by which the uh, the promise maker has the commitment to enforce this agreement and make it a contract. Otherwise, without this duration period, we will not having any expectation about the existence of this promise. Now, what's going to happen if somebody make a promise to buy something and the other party accepts this promise? When this one of the parties ask the other one to enforce this agreement or this promise, we have a scenario where one party say, no, I will not do it. I will not do it. He refuses to do so. In this case, if the other party wants the enforcement of this promise and claim it, he has to go to the court, and the judge will have the capacity to make this promise be enforced and be fined. Now, in this case, the court's judgment will be then conclusive and final. Now, we would like to understand what is the difference between the promise to enter into a contract and the preliminary contract. The preliminary contract. The preliminary contract, it is, from its meaning, it is a contract, but it is not a final. It is a preparation for the final contract. In this sense, this preliminary contract has legal rights and creates legal rights and obligations, and it has all the aspects of a contract. But the promise, as we mentioned before, it is a future commitment or a discussion about a possible contract. By this, I conclude my presentation for this class, and please follow up my next classes. Thank you so much.